I'm Becky Rupert McMahon. I'm the Chief Executive Officer here at the Cleveland Metropolitan Bar Association. And hosting the kind of conversation that we have today is right down our sweet spot. As an organization that strives to be the go-to organization on issues of law and justice in Greater Cleveland, having a conversation that is both constructive and civil between the two candidates who are vying in the primary for the Cuyahoga County Prosecutor's Office is exactly where our bar should be. Our goal is to help inform and to educate and to arm everyone who's out there watching this program today with information that will help you make up your minds as you head to the poll in the primary coming up. Our conversation today, I'll make an introduction in just a moment, will be led by Matt Besser, who is the incoming president of the Cleveland Metropolitan Bar Association this summer. He'll be inaugurated at our annual meeting that will be happening on June 12th. Tickets on sale now. If you'd like to get that ticket request in early, we would be delighted to see you. And as we finally get to the point where it looks like we've got a near critical mass coming in to join our conversation today, I'm going to make one more plug for our bar, which is we have one of the biggest events of the year happening this weekend at the Music Box Supper Club. Rock the Foundation is our signature fundraiser of our bar foundation. It is an event that is raising money to, among other things, launch the Cleveland Legal Collaborative, which is a brand new program going online this summer. It's an incubator that will be training next generation lawyers to serve individuals who are caught in the justice gap, people who make too much money to qualify for free legal assistance, but nowhere near enough to afford market rates for lawyers that put themselves out for a hire in our community. So come join us this weekend at the Music Box Supper Club, Saturday night. Tickets on sale, as you can see in the chat, at www.clemetrobar.org/Rock the Foundation. And with that, I'm going to make a very brief introduction of today's facilitator for our conversation. I mentioned a few moments ago that Matt Besser is the incoming president at the Cleveland Metropolitan Bar Association. He takes over at the end of June as Judge John Russo completes his year as president. Matt is one of the founding partners of the law firm Bolick, Besser, Glesias, where he is a champion for the rights of individuals in employment discrimination, constitutional, and civil rights cases. Matt is an experienced and accomplished negotiator, litigator, and appellate lawyer, so he is a terrific person to lead today's conversation. And with that, Matt, I'm going to say thank you and turn it over to you to introduce our candidates and kick off our conversation.
Well, thank you, Becky. Thank you to everybody joining, and a special thank you to our candidates, Prosecutor Michael O'Malley and Professor Matthew Ahn. Thanks to both of you for taking the time and speaking with our members today. Because we're structuring this more as a conversation than a debate, we won't stick to strict time limits, but for all of you in the audience, both the candidates have committed to having this be a substantive conversation, and we'll be respectful of everyone's time so that we can talk about some of the critical issues. And with that, I'd like to ask both the candidates to take 2 or 3 minutes at the start to introduce yourself, tell us about yourself, and I've challenged both of them before we started today to do that without referencing your opponent. So, that being said, we'll kick it off to Matthew Ahn, and floor is yours.
Hey, thank you very much, Mr. Besser, Ms. McMahon, and to the CMBA for hosting this event. I'm honored to be here. My name is Matthew Ahn. I'm a law professor at Cleveland State with a decade of legal experience across criminal and civil litigation. And I'm running for Cuyahoga County Prosecutor because I believe that we can create justice for all. Now, justice is educational security, which I helped low-income and first-generation students pursue while teaching at Tri-C. Justice is also the opportunity to succeed, which I fought for as a special education attorney, representing parents whose children were being denied accommodations. And justice is rehabilitation and success upon reentry, which I helped my clients achieve while serving as a public defender in state and federal court. And the fundamental truth is that we create justice for all when we think big about what our communities need and when we seek to prevent crime, not just react to it. Now, I've been fighting for this big picture thinking my whole career, and I've succeeded at every step. My special education work resulted in relief in every case I filed. And as a public defender, I won numerous appeals, as well as federal suppression motions, Rule 29 motions, and applications for post-conviction parole relief. In fact, the Sixth Circuit legal standard for federal compassionate release that was just folded into the federal sentencing guidelines originated from a series of appeals that I filed and argued. In other words, I'm well versed in the evidence-based, data-driven strategies that best hold people accountable, and I'm experienced in prioritizing prevention, rehabilitation, and critical services for communities. Right? I've grappled with these complex issues, and I've followed the data, and I understand how to fold these best practices into a successful litigation strategy. Being able to share these practical insights with our future leaders at CSU Law is part of why I was voted Faculty Member of the Year last year by the students at CSU. I know we're going to get into the policy, but I'll just note now that Cuyahoga County is a state outlier on most criminal justice outcomes and a national outlier on a few. And so that's why, as your prosecutor, I will target the crimes that harm our community, build an office in the people's interest, work to break the cycle of trauma, and support rehabilitation through services, because that is justice for all. It's what our communities have been asking for, and it's what they deserve. So that I hope on March 19th, you'll vote for me, Matthew Ahn, that's spelled A-H-N, for Cuyahoga County Prosecutor. Thank you.
All right. Thank you very much, Matthew. Prosecutor O'Malley, floor is yours.
Sure. Thank you. I want to just thank you, Matt and Becky, for hosting this important event today. And let me just say, this election isn't about campaign stump speeches. It's about experience keeping our community safe and running an office of 400 plus employees who deal with the most critical issues facing the residents of Cuyahoga County. We can talk about experience. I have been a practicing lawyer for over 3 decades. I started my career both as in a private law practice, doing both probate, criminal defense work, civil litigation. I also worked as an assistant law director for approximately 5 years. I was the first assistant county prosecutor for about 6 years. I have a wealth of experience before I ever even contemplating running for this position. In this position over the last 7 years, I have led the charge on doing things like creating a early intervention and diversion center for juveniles, where prior to that center, individuals would be brought into the system and there would be no diagnosis or no deep dive evaluation till their case was concluded. Since we have pushed and founded the early intervention and diversion center, we now have approximately 3,000 cases. All of those cases are evaluated on the front end. We are diverting 1,000 juvenile cases. And again, that has all been done under my leadership. Second, we've had issues like created the adult diversion center over on East 55th Street, where now to keep people out of the county jail, as well as to provide services for individuals with mental health issues or substance abuse issues, family members or law enforcement agencies can take people to the diversion center 24 hours a day, 7 days a week, and get them back to health and to keep them out of our county jail. So what we've seen is leadership. Let me also say that as the county prosecutor during the pandemic, I assisted along with the common pleas court judges to guide the criminal justice system through the first pandemic in decades and decades and decades. And we did in such a way that we protected the defendant's rights while also keeping the criminal justice system moving. That's all about experience, but it's also about leadership. None of those things happen in a vacuum. It takes people who have the respect, the experience, and the knowledge of the system to get all those things accomplished. And then let's talk about philosophy. You know, by creating things like an early intervention center, by creating things like a diversion center, what we are doing is keeping those people out of the cycle that we have seen in the past of constant and frequent interactions with the criminal justice system. We have established programs to get people healthy, to keep people out of the, and to reduce recidivism. Again, all of that happened under my tenure. I'm an experienced attorney. I am an experienced manager of people, and I bring a great team of experienced supervisors and leaders in that office who are working hard on behalf of those people in Cuyahoga County that we represent.
Thank you very much, Mike. I had planned on talking about this later, but you raised it. So I want to ask you about, both of you, about the diversion center. Because mental health is going to be a large focus for the Bar Association in the next year. And I think we all know that many who come into the criminal justice system are struggling with mental health, substance abuse issues. So we have this new diversion center. There have been some reports about it being underused, that many of the beds have been empty. And so I wanted, maybe I'll ask you first, Mike, if you could talk to us about how you think the diversion center is doing, how it's progressing, and should it be used more? And if so, what do you view as the role of your office in influencing law enforcement to bring folks to it? And then obviously I want to hear Matthew's views as well.
Well, certainly, you know, last year, over 1,300 people, my recollection off the top of my head, individuals entered the diversion center. It's growing year by year, the amount of people. Certainly at the initial opening, there were some departments that were hesitant, especially, which was the tragic part, including the city of Cleveland, who, in my opinion, had not been bringing enough individuals to the center. But we are seeing it growing year after year after year. What I've done with the diversion center and what we've rolled out to the law enforcement agencies on low-level felonies, we are willing to divert people who are entered into the diversion center, again, in an effort to have them avoid the criminal justice system, divert their cases, not formally charge them, and get them and restore them back to mental health. And that is our goal. Through the decades and decades and decades of the criminal justice system, we have not had a facility like this. And I'm proud to say, under my leadership, the county jail, which when I took over was roughly at 2,200 detainees, we are hovering anywhere from 1,400 to 1,450 detainees currently, depending on the week. And that's all through the leadership of things like the diversion center, of working with the court, and my establishing a policy to keep those low-level offenders out of the county jail. Because again, my goal is to get those individuals out of the criminal justice system and restore them back to health, so we don't have the recidivism we had in the past.
Thanks. Matthew, what's your view on the diversion center and the prosecutor's office role in encouraging law enforcement to use it?
Absolutely. I think that the diversion center, when utilized properly, is a really powerful tool for us to break the cycle of trauma, coming back to my third point in my platform. Now, the problem is that the diversion center has not been used to its fullest extent for that purpose. From the time that the diversion center opened up until the last quarterly report of the diversion center, which I believe was in November of 2023, only 117 people were brought by police officers to the diversion center in lieu of an arrest. In other words, right, the vast majority of folks that were brought by police to the diversion center were brought without any potential of arrest in the alternative. So in other words, right, we're only talking about 117 people who would have otherwise been charged who were brought to the diversion center. The vast majority of these folks were charged with misdemeanors, and so likely would have been subject to only a very short jail stay, if any. In other words, the diversion center at this point has not yet had a meaningful impact on the jail population. And so I believe that there is still a lot to do in terms of encouraging police departments to use the diversion center to its fullest extent. That is something that I would make a priority, both in terms of top-down conversations that I would have with police chiefs, as well as conversations that individual prosecutors would be able to have as well. I believe that there is still a lot that we can do to actually meaningfully reduce the jail population. The jail population reached a low of 950 during the COVID-19 pandemic. It actually, that population rose to what was reported between 1,650 and 1,700 in the last couple of years. And when we're talking about a jail population that high, 117 people over
Well,
2.5 years is not,
Matthew, not to cut you off, because
Sure.
we may get into the jail population.
Great.
And, we got a lot of questions from folks and a lot of topics to cover. One of the main topics that people have a lot of questions about is bail reform across the country, in Ohio, Cuyahoga County, and there's a lot of questions that we've had. I'd like to ask both of you, I suppose we'll start with Matthew. What's your stance on the use of cash bail? Does it have a disparate impact on people of color? Does the inability to post bail correlate with higher chances of incarceration? Tell us your views generally on cash bail.
Sure. This is where I was going anyway, so this is a perfect segue. I have already committed to not asking for cash bail, because cash bail is a system that does not have a whole lot to do with public safety. It is based more in whether you have the ability to pay your way out of jail. We currently have a system where folks are in our county jail right now because they cannot afford a relatively low cash bail amount. And we also have a system where people who are charged with very serious crimes are still given an opportunity to pay their way out of jail. Even some of these very serious crimes that we've seen charged, folks are still receiving a cash bail amount and on occasion being able to pay their way out of jail. And so, we should be using a public safety-based system. Either you are a threat to the community or a flight risk and you should be in jail, or you're not, and you should be released with whatever conditions will ensure the safety of the community. That is a system that actually comports more with public safety. Now, my opponent in the past has said that the cash bail issue is not a large problem because we now have an outpost of the Bail Project that helps bail folks out of jail, and it just seems odd to me that that this is a problem that he is able to solve, but believes that since somebody else is expending resources to solve it, it is no longer sort of in his sort of priority list. And
let's since you raised them, let's hear Mike's view on cash bail. You've given us a good segue. So Mike, what's your view on cash bail?
Well, let me step back where we were before I got into office and where we're at. Before I came into office in 2017, the prosecutor's office had free rein, those in the arraignment room, to object or debate what the appropriate bail amount should be. When I came into office, I enacted a policy, and as Matt's probably aware, in Cuyahoga County, we have something called the bond commissioner, who does the background evaluation on all of the individuals appearing in the arraignment room and makes recommendations to the court on every particular case based upon the individual's criminal history, the threat to the community, the risk of flight. And so what they do is they make these recommendations to the sitting judge in the arraignment room. I enacted a policy upon coming into office that we would not object to any of the recommendations of the bond commissioner, in that the only time we would object, which happens extremely rarely, is that if there was a risk of flight or there was a potential threat to the victims. So, in less than 1 out of 100 cases do we ever make a comment regarding the bond. And as we all know, currently, it's up to the common police court judges to determine what they feel is the appropriate bond requirements of the court. I've made my recommendations. I agree with Matt. I have worked with Kareem Henton at the Bail Project to get individuals released, especially those on low-level bonds. I've let my feelings known is that I don't think we should hold people on low-level bonds, that people should be entitled to remain free. I'm glad to say, and I'm proud to say, that during my tenure, we now have, working with the court, 600 plus individuals out on pretrial release on ankle monitors, which has also gone a long way towards eliminating the population of the county jail. And I got to give my hats off to the county sheriff, who monitors the individuals out on pretrial release and who are on ankle monitors. So I think during my tenure, the fact that we've now established a new bail policy which is to not object to the recommendations of the bond commissioner's office. The fact that we have had a massive growth in the amount of people out on ankle monitors, which I think is a great thing, has absolutely changed the dynamic, which has also allowed the population to be dropped from, like I said, 2,200 to 1,400, which is a drop of more than 30%. So much consistent with Matt, I don't think people should be held on these low-level cash bonds, but I think some of the things we have taken, the steps we have taken has certainly drastically reduced the amount of people in the county jail, and I'm proud of that work.
Mike, can I ask you a follow-up? Could your office, or have you given consideration to taking the next step besides not objecting and taking the position that, the office doesn't think cash bail, cash bond is necessary? And are you familiar with the stats? Do you agree with the stats that the inability to post bail correlates with worse outcomes at the back end in the criminal justice system?
You know what I don't like about the cash bail system, and I've let my feelings be known to the judges, is that I don't like with the potential that while you are detained, that gainfully employed people perhaps lose their employment. So I've certainly let my feelings be known, but it's not a decision that's within my authority, but I've let my feelings known. And I do, the troubling part is that when people are being held on small cash bails that they cannot afford, I don't like the social impacts of losing employment, losing housing, and those type of things.
Matthew, any follow-up?
Yeah, I mean, I think the ill effects of somebody who is held in because they can't pay their way out. That is exactly what we are seeing. I mean, this is something that is still happening, right? And if it's still happening, I think it means that the policies that we have don't go far enough, and we can go further in terms of our cash bail policy and actually just move away from it altogether. I do appreciate the mention of Kareem Henton, who is one of the experts sort of on cash bail in this area. And I am proud to say that Mr. Henton has endorsed my candidacy for Cuyahoga County prosecutor, because he understands that I've seen sort of the data and the research about the ill effects of cash bail. And I understand how best to work to solve that problem here in Cuyahoga County.
Appreciate that discussion to both of you. I want to shift gears and talk about the jail and justice center. It's obviously another big issue. It appears that the jail is moving to Garfield Heights. So, my question for both of you is where should the jail be, and where should the justice center be? I'd like to ask the prosecutor first.
Absolutely. Let me start out by saying, the last county executive trying to push a county jail on the transport road site, and I led the charge to stop the jail because I felt rebuilding a jail on a toxic waste site would be an absolutely terrible idea for Cuyahoga County, for both long-term effects on detainees as well as the sheriff department employees who would be stationed there for decades because of their employment. So I led the charge to stop that. I do believe that the Cuyahoga County does need a new jail. I think whether we could rebuild on site would be a difficult assignment, given the fact that we currently have 1,000 people in detainment, 1,000 people in detainment. So my initial feelings are that I'm not happy to see it moving out of the downtown area. I wish we could have used things like the county land bank and the like to perhaps have it located closer to the downtown area, given the fact that we do need a new jail. The Garfield site has been decided by the county executive as well as the county council. That legislation has been passed. So I think we're at a point now where they're talking about having a full service campus out there that would include the diversion center. So it seems like that ship has left the port due to the fact that the legislation has been passed, as well as the legislation for financing. So I think now the question is, how do we make it convenient for the citizens of Cuyahoga County? And I think that's going to take a combination of working with our regional transportation agencies to make sure that families as well as those who are being released, have access to public transportation. But my first, to summarize it, would be that we had built a facility much closer to the downtown area, but that was outside of my authority. County executive and the county council have made that decision, and I just hope that now that they've made that decision, that we can at least accommodate the citizens of Cuyahoga County with easier access.
What about the Justice Center?
I think the Justice Center needs to, my guess, and my opinion is that it needs to be rebuilt. You know, I don't know that the county, given its current financial and fiscal situation, has the ability to build a new site, to build a new building. So my preference would be to see it restored and renovated in its existing site. And if the county jail does move to a new site, which looks like it's going to Garfield, that perhaps those existing jails being torn down and additional public parking be made in those areas to make easier access for the public. Because I think right now the current center does have, given the fact that 500 spaces have been given away at the Huntington Park Garage to the Hilton Hotel next door, I don't think any consideration was given to the public or the criminal justice system when that decision was made. And I think rebuilding and restoring the Justice Center at its current site and adding additional parking is the route to go.
Matthew, what's your view on location of the jail and Justice Center?
Sure. I was also very active in opposing the Transport Road site, and I'm glad that that proposal did not move forward. One of the things I did as a member of Clevelanders for Public Transit was film a time-lapse video demonstrating the distance of that site from the nearest public transit, which was one of the reasons that now County Executive Ronayne mentioned in his letter saying that he would not support that site. Now, the Garfield Heights location, I think, is a problem, and I made this clear in numerous comments to County Council last year, including for a number of reasons, including when you separate a jail and a court system, you end up with detained individuals late for court at a much higher rate. You're going to end up with folks who have bond modification hearings that they're going to be late to. They're going to stay in jail longer than they need to. In addition, having the separation is going to create additional continuing costs in terms of transportation vehicles and staff and maintenance for those vehicles. There's also a number of new weak points in terms of an escape risk, right? On top of that, this is a problem for all of the attorneys who have to visit clients in the jail, right? It's a logistical mess. And so I believe that the entire complex needs to remain somewhere hopefully close to downtown. I believe there is actually some law that says the courts need to remain downtown. Therefore, I would like to see the entire complex remain as one sort of set of buildings somewhere in the downtown area. I believe that that is both going to be the most convenient for folks who have to visit people in the jail, as well as folks who have to visit the Justice Center. I want to point out that the question of the jail location is challenging because, again, I believe that the jail population is higher than it needs to be.
Well, hold on. I do want to stay a little bit on topic if we can. So apologies. I just want to shift our gears so we don't run out of time. Just a reminder to folks, we're getting a little bit of emojis popping up in the windows. So if you could all keep your emoji reactions maybe to yourself, that would be great. Maybe at the end we can all do a group emoji about our views. But thank you. So I do want to ask a follow-up question about Jail and Justice Center, and that relates to the involvement of the private practice bar. You know, CMBA members, private practitioners represent full cross-section of the community in both civil and criminal cases. But private practitioners have been excluded from the process of determining where jail and justice center should be. And so my question first to Matthew and then to Mike is shouldn't the private bar be part of this process in determining where the justice center goes?
I would agree with that. I mean, I think part of the reason we have ended up in this situation is because the steering committee was functionally dissolved back in late 2022. So really this has been county government's project for the last year, year or more. And I think that more stakeholders are having their voices heard and having input is always better. And that's why one of the things that I want to do, just as a general matter, as your county prosecutor, is really sort of foster that spirit of collaboration and actually, allowing folks to provide meaningful input. Stakeholders such as the private bar, stakeholders such as other county or municipal agencies, but also the public as a whole, just in creating a more transparent and responsive prosecutor's office.
Mike.
Yes, I was just trying to digest that answer, but I'll just say this. I think, because I don't know that Matt answered the question. Here's what I believe. I believe that this is a county structure, and I think it's up to county elected office holders to make these decisions. Unfortunately, the problem here lies with the structure of the current county government. If we did not have this chartered government, the judicial system with the clerk, the sheriff, the judges would be driving the train. But the problem is, under our current form of government, the cards are now held in the hands of the county executive, which means because he appoints the clerk and he appoints the county sheriff. So what we have seen is a situation where the court system should be driving it, who would be much more responsive to the bar, and I think much more sensitive to the needs of the bar community, as well as the prisoners, their families, and everything else. What we have now is a situation where the authority and the decision-making capacity has been taken away and given to the county executive under this form of government. So what I think we need to do is change the state law and have it address the situations within Cuyahoga County and put the authority for both the jail and the courts back in the hands of the third branch of government, which is that of the Cuyahoga County Common Pleas Court. And that's the problem that we're having here, in my opinion. And it's why we need, and we have reached out to people in Columbus to try to address this situation so that the court is again put in control of its own destiny.
So you wouldn't be in favor of giving the private bar their own seat at the table? You think this should be handled through other channels?
I think that people elect county office holders for a reason. It's to make the decisions of county government. And the question would be, where does it start and where does it stop? Do we let police agencies give their opinion? Do we let attorneys give their decision? Elected officials may need to make the decisions that they're elected to make. Again, the problem in Cuyahoga County is because, as you know, the bar is in front of the court all the time, and they hear the needs, and they have similar desires and wants. And so I think the issue is, to simply state it, is that I think it should be up to the elected officials to make the decision of elected officials. And I think that the current structure of our government and the current state of the state law has misplaced in the hands of the executives all of these decisions, and I think that needs to be corrected.
I appreciate it. So if we've gotten more questions on any topic than anything else, it's juvenile bindovers, transfers. Let's talk about the use of discretionary versus mandatory bindovers. So just for people who aren't familiar, Mike, if you could just give a brief 30,000-foot overview of when offenses are mandatory versus juvenile, and then maybe talk about how your office decides on whether to seek a discretionary, and then obviously we want to hear from Matthew as well.
Okay, sure. Generally, mandatory bindovers are individuals who are 17 and 18, depending on the case, but it's generally felonies of the first degree, second degree, where they have the gun. So whether it's an ag murder, those cases, it's with the gun or not, but ag robberies in particular. So it's high-level cases where individuals have a gun. They're 17 and 18. In a murder situation, their accomplices would be a mandatory bindover. So let me give you a stat. Last year, 80% of the bindovers were mandatory. So that means that when there's probable cause to demonstrate that they're involved in that situation, they are automatically mandatorily bound over. Last year, we had 9 new discretionary bindovers, and discretionary bindovers are generally individuals who are 14, 15, 16, and 17 but it may not be the primary focus, or if you're 14 and 15, you can commit actions including aggravated murder. If you're 14 and 15, even if you're the gunman, even if you pull the trigger, those cases would be discretionary. So let me give you an example of the 9 cases, for instance, last year that were new discretionary bindovers. And just so people understand, what happens is the court can make a motion for a discretionary bindover, or we can. And what it does is requires a report to be constructed, and a deep dive occurs with that individual. And so we will file a motion, and what that does is has the court, it initiates a investigation and evaluation of this individual, where the court's professionals will do mental health evaluations, screening, look at their educational background, look at their priors. How did they respond to previous treatment? How did they respond if they were previously on probation? And those things are then done by the court staff. A hearing is then held in front of the court. So what our discretionary motion does is it mandates that the court does a report, and then ultimately it's up to the juvenile court judge to determine whether that individual who has a discretionary bindover is amenable to rehabilitation in the juvenile system. So like in short summary, on a discretionary bindover, either we file the motion or the court files the motion, but ultimately it's up to the juvenile court judge to determine whether the individual can be rehabilitated in the juvenile system or not. And like I said, last year, of our bindovers, 9 new bindovers, and of those 9 new discretionary bindovers, and of those, I think 3 were murders, 2 were attempted murders. So these are very, very serious cases. And if you are being bound over, last year, for instance, of all the bindovers, 53% were ag murder, attempted murder. So these aren't like kids stealing Hyundais and Kias. These are individuals with guns who are causing havoc and causing a lot of damage in the community.
Thanks. Matthew, I know you probably have much to say about the discretionary juvenile bindovers. So you want to tell us your view?
Sure. And I will say, you know, I'm not going to be able to cover all of my thoughts here. We have a series of videos on this topic on my social media, on my YouTube page. So I'd encourage folks to check those out as well. Now, the data and the research on juvenile bindovers, I think, is relatively clear, both in terms of best practices and what has happened here in Cuyahoga County. Over the course of the early to mid 2010s, the rate of juvenile bindovers was declining here in Cuyahoga County. Starting in 2017, we saw a massive uptick in the rate of juvenile bindovers when my opponent entered office. And that rate has remained high for the last several years. I want to note that while we are seeing a serious uptick in serious juvenile crime, that is an uptick that actually comes after the uptick in juvenile bindovers. And so, you know, this is something that I think is a practice that is not actually borne out by data and research as something that is effective. All of the studies that we have demonstrate that children who are tried as adults and sent to adult prison are much more likely to commit more crimes upon their release, as compared to children who are kept in juvenile court for the exact same charges. And so this is a practice that is also subject to a very severe racial disparity here in Cuyahoga County. Over 90% of the children tried as adults in recent years are Black. So this is a practice that I want to take a very close look at. You know, a lot of data regarding these cases is not public, and so what I have said is I'd like to put a pause on the discretionary bindovers so that we can actually understand those disparities, and so that we can come up with a system that is fairer, that is more data-driven, that is more evidence-based, so that we can actually best hold children accountable in a way that will make sure that they are not going to come before the court again. And I want to be clear, I'm not saying that children who commit serious crimes don't require serious punishments, but there are mechanisms such as the serious youthful offender sentence in juvenile court that are available even when a child is kept in juvenile court. I could rant for hours about that.
Please don't. Please don't. I want to give Mike, if he's got something new to add, if you want to take 30 seconds to respond to Matthew's points, before we move to other topics.
Yep, absolutely. We have a constitutional amendment that was passed in the state of Ohio a number of years back called Marcy's Law that requires my staff to meet with victims' families at every critical point in the processing of the cases that we have. And, Matt pledging to, as he calls it, a moratorium is basically a mandate that he will ignore the will of the victims. And it's a violation of his oath. It's a violation of the Constitution of the state of Ohio to tell people on the front end, I will not listen to what your views are. I have made a decision and I have predetermined the outcome of this case. And I think, quite frankly, it's a violation of his ethical duties. And the fact that he doesn't realize that is troubling. And again, we use data every day in our office to solve crime, to determine who's committing crime and to prevent future crime. Matt has never been involved in the criminal justice system.
Well, hold on, Mike, before we certainly talk about that at the end in your closing. I do want to be, respectful of the different topics we've got folks wanting to ask about. I'm going to turn to conviction integrity, but Matthew, I'll give you an opportunity to respond as part of your answer. Take 30 seconds or so to respond. And after that, if you could dovetail into conviction integrity. We've had questions about the conviction integrity unit. What would you do with respect to that unit if you're elected?
Absolutely. So I'll just very quickly, I want to point out that the principles behind Marcy's Law are the sort of 5 pillars of victim advocacy: confidentiality, privacy, informed choice, self-determination, and autonomy. These are the kinds of things that should govern the conversations that happen under Marcy's Law. And that, the idea that somehow, that victims are, it is I think, a misrepresentation of what Marcy's Law does. Marcy's Law is about, victims having rights to be heard. And I want to point out that my data and research-driven strategies are those that are going to create fewer victims in the future, rather than sort of rely on victims as a political tool. Now, in terms of the conviction integrity unit, I want to, one of the things that I really want to do is restore that unit to its former functioning. And there was an external board of the conviction integrity unit that all sort of resigned together in late 2022. I believe that external board should be reconstituted, and I think it can be strengthened in a number of ways. I'd like to include at least one formerly incarcerated person on that external board. I think that that thinking about wrongful convictions, and I think should back up here, the conviction integrity unit is a unit that is supposed to review wrongful conviction claims and decide what kind of sort of potential resolution there might be in conjunction with the prosecutor's office. Now, I believe that justice is about getting things right, no matter how long it takes. And so this external board really should have power and input that at least the board that resigned believed it did not have sort of more than on paper when they resigned. And I believe that we can take a much more sort of collaborative approach to wrongful conviction claims, both through the use of this conviction integrity unit, but also with an appeals and post-conviction unit that is willing to not contest certain wrongful conviction claims as they come up, is willing to have sort of post-conviction open file discovery, especially understanding what past practices were in the prosecutor's office with regards to evidence disclosure. These kinds of best practices that will allow us to make sure that we don't have anybody who is in prison right now who was wrongfully convicted, because I think we've only just scratched the tip of the iceberg in terms of these wrongful conviction claims.
So thank you. Mike, I've got two follow-up questions for you as you respond. As I understand your office's public statement when the external review panel resigned, it was that the external review panel your office felt was damaging to the efforts of the integrity unit because defendants were attempting to use that existence of a panel deliberation as evidence in support of a post-conviction relief claim. So if you could just address why, in your view, that outweighed the viability, the use, the need for an independent voice as part of an integrity unit related to that. There's been a lot of discussion about best practices for conviction integrity, including external voices and having folks report directly to the head of the office, those sorts of things. So part two, I suppose, is what has your office done? What are you doing to ensure that the CIU is following best practices?
Sure, absolutely. Well, let me just start out by saying this. I created the external review board when I came into office. It didn't exist prior to my tenure in 2017. So I was the individual who created it. And it was doing what needed to be done. Unfortunately, what has happened is that the correspondence, and again, there are lay people, there's non-lawyers who've been on and are on, we're on the Conviction Integrity Review Board. And, they're what we did when I established it was try to get an independent set of eyes. And we didn't anticipate that criminal defense attorneys would attempt to use their deliberations as evidence of whether an individual should be granted release because of wrongful conviction. Because quite frankly, many of them don't know the nuances of criminal law because they're not attorneys. And so what we had was in a situation where people began to subpoena their text messages, their emails and the like. And the problem is that we couldn't, while we may have filed a motion to prevent that from happening, we couldn't represent them. So the problem became of our own creation. We want it, we decided to do it, and then it came back in the end to not be what we had hoped for. But I am proud to say the rate of relief for my Conviction Integrity Unit is 15 times better than that of the Ohio Innocence Project. We have a rate of relief greater than 5%. We've just vacated another conviction in the last several months of an individual charged with a sexual assault. So we continue to do good work. I'm proud of the efforts of the individuals within my office who are working in the conviction integrity area. And like I said, I'm proud to say that we have a rate of relief 15 times better than the Ohio Innocence Project, which should tell you the type of work we're doing.
Well, yeah, 1 second, Matt, I do want to hear. But what is the office doing to ensure that it's following best practices on things like independence and transparency?
Certainly, we have several individuals assigned to the unit. Like I said, with the independent review board, I gave them the opportunity whether to restructure the board or to that, because we couldn't go under the way we were going, even though I had hoped we could. So we're being transparent. We'll certainly let attorneys know what's going on when they file their applications. Some investigations take years, others are done much sooner, but we continue to work every day. When we are finished with our investigation, we let people know. But the key is to try to get things right and to try to turn over every stone that we can when we're looking at these post-conviction issues. And that's what we do. And I'm proud of the work of the unit.
Matthew.
Yeah, I want to point out a couple of things, including that, once again, this is an area where there is not a lot of transparency in terms of what the work is looking like, what kinds of claims are coming in, just even in the aggregate, like top line numbers. And so there's not really a way to understand, right, how the conviction integrity unit is doing right now. And in addition, I think this is sort of at least somewhat belied or inconsistent with the approach in a lot of these cases where we're seeing convictions overturned through the courts. A number of folks have had their convictions overturned generally because of Brady violations over the last several years. Folks who are let out of prison after 20 or 30 or 45 years. And in these cases, the prosecutor's office has repeatedly chosen to take those folks back to trial on their original decades-old charges, despite the new evidence of this innocence. And these are cases where folks are getting acquitted, sometimes in as little as 15 minutes. And it's just, you know, I think it's a waste of public resources and a waste of everybody's time. And
these are obviously critically important topics, and we have a lot to cover. We have limited time left, and I do want, to cover capital punishment very briefly. So if each of you, before we move into sort of closing remarks, if each of you could, in a minute, tell us your views about capital punishment, whether it's ever justified, and frankly, is it applied in a racially disparate manner? Matthew, if you'd like to go first.
Sure, absolutely. Moral questions about the death penalty aside, it is a policy failure on every front. Jurisdictions with the death penalty have higher murder rates than jurisdictions without the death penalty for every single year that we have good data. We know it is prone to error. There have been 8 wrongful death sentences in Cuyahoga County alone, and it's prone to racial bias as well. It also happens to be more expensive than sentencing somebody to life in prison. Especially when folks in Columbus are talking about trying to execute folks via nitrogen hypoxia after witnessing a single botched execution in Alabama. I think there's a clear choice here between somebody who over the first 5 years, 5 full years of their tenure, issued more death sentences than any other county in the United States, and somebody who has pledged not to seek the death penalty and instead would give victims the closure of not having to go through death penalty appeals and would seek life in prison without parole for the most serious and most heinous crimes that we see. That is better accountability, it is better for victims, and it is better on a policy level.
Thanks. So Michael, if you'd like to share with us in a minute or so before we move to closing, your view on capital punishment.
I'm not certain I understood Matt's view after his 3 or 4 minutes. So
you got 1 minute, so go ahead.
Well, all I can say is I still don't understand Matt's, but I can tell you this: just so we're all clear, it's a jury of Cuyahoga County residents who determine whether to go with a capital spec on a case. And we have not had one in Cuyahoga County in 4 years. But in those cases where jurors have decided that the appropriate punishment is capital punishment, and the judges of that particular trial have also affirmed that decision, I'm not going to second guess those jurors who are making the ultimate and the toughest decisions that a group of individuals can make. So I can tell you this: I certainly, my feelings on capital punishment have certainly evolved. I do a lot of self-reflection as the prosecutor. All of these cases are serious. As I said, we have not had a capital case in Cuyahoga County in over 4 years. But do I think there are situations where, when I see the mass death, the type of situations where we have school shootings or people shooting up nightclubs, or just these situations where people are causing a lot of people to lose their life, I certainly think in those particular situations, it's something that jurors should at least be able to evaluate. And yeah, that's my feeling. And so you don't see it anymore in Cuyahoga County, but I can tell you this: if we have a mass shooting where there's mass casualties, my guess is you'd probably see it again.
So these are obviously, hold on, Matthew, for 1 second. These are obviously critical issues. There've been a ton of really important questions, and if we had more time, we could cover some of these things in more depth, and I wish we could. But we do have a hard stop here. So I'd like to give each of you, as I promised, 2 minutes to make your case, and here I am going to be a little bit of a stickler for the time. So frankly, don't remember who we agreed would go first on closing, so someone could jump in and tell me. I think we said that Matthew would go first on closing. So 2 minutes, it's a hard 2 minutes. And thanks again for being here today.
All right, thank you once again to everybody for putting on this event. It's been an honor to share my vision for a safer and stronger Cuyahoga County with you. What you've seen here today is a stark contrast in approach. I am looking to really use the data and the research about addressing and preventing crime. I'm looking to make sure that the office is running with the best practices possible, rather than just, the first step in improvement. That is not the way that my opponent has run the office. That is not the way that we have seen the office run. We have seen instead policies that worsen racial disparities and make us less safe. We've seen a spike in serious juvenile crime, and we have seen a number of policies that are not borne out by the research and the data that we've already covered here today. We can do better than that, right? We can target the crimes that harm our community. We can build an office in the people's interest. We can work to break the cycle of trauma, and we can support rehabilitation through services. I have the experience in understanding these really big, complicated issues. I have experience in collaborating with folks on them. I have experience in folding them into successful litigation strategies. At every single stop that I've had, I have won. And that is what I want to bring to this office. I want to bring to this office the understanding that administration and management creates outcomes and is policy. I want to give folks in the prosecutor's office the tools and the ownership over their work that allow them to do the best work that they possibly can. I hope that you'll join me, Matthew Ahn, on March 19th and in the years to come as we build justice for all. I hope that you would go to my website, matthew-ahn.com, to learn more, to donate, to sign up to volunteer. We're going to do this together. Thank you very much.
Professor Ahn, thank you so much. Prosecutor O'Malley, the floor is yours for 2 minutes.
Absolutely. This race is really about experience and leadership and management. And certainly when you look at the management, I have been in charge of 400 people in this office. I was in charge of several hundred people when I was the safety director of Parma. I was in charge of several hundred people when I was the first assistant Cuyahoga County prosecutor. I've received virtually every endorsement. The plain dealer referred to my opponent's campaign as frightening. And really what it comes down to is telling people the truth. When Matt talks about data and being data-driven, the reality is he's never had a case. He's never worked with law enforcement. He has no idea what data we use. He has no idea how we use the data we do and what we do with the data. I have been involved in the criminal justice system for 37 plus years. I work with law enforcement. I work with our community leaders. It's why virtually every community leader in this county is supporting my candidacy. It's because experience does matter. And to take an individual who got its Ohio law license in 2022 and has never practiced law in any of the courts where we work, has never represented a criminal defendant in common pleas court, has never prosecuted a case, has never been in juvenile court, has never done anything since he's returned to Cleveland in the way of practicing law. It comes down to experience and leadership. I've led this as the county prosecutor. I led some of the best advancements we've had in the criminal justice system over the last 7 years. I led it through a pandemic, and I will continue to lead it when I'm reelected in next November. So I appreciate your time. I want to thank Matt and Becky for hosting this critical event, and I want to thank Matt for participating as well.
Well, thank you to both of you. And first of all, 100 points to each of you for sticking to that 2 minutes at the end. I know there's a lot to cover, and this is a complicated series of issues that the prosecutor's office faces. And so I thank you for being succinct and having a substantive discussion in the limited time we had today. To all the audience, thank you for being here. If you're here, it's because you care about the cause of justice in our county. And there is always a lot of work to be done, civil and criminal. And so I encourage everybody to stay involved, not only to educate yourself about this race, but also about the judicial races. And CMBA is part of a consortium of 6 bar associations, the Judge for Yourself Coalition that rates judicial candidates in an independent and nonpartisan way. So I commend you to those at Judge for yourself. That's the number 4.com. And whatever your passion is for the cause of justice, for the rule of law in Cuyahoga County, you can find it at the Bar Association. So I encourage you all to be involved at the Bar Association, to join, to be more involved if you're already a member. And you can find your passion for justice with the bar at clemetrobar.com. And with that, I thank everybody for their time and make sure everybody votes this March.
Thank you.